Well, we've just hit noon. I think I'm going to give 30 seconds just for people to get in. And I know we've got a lot of folks joining. The number of participants is going up. So why don't we, those who joined right at noon, get a second. Looks like it's slowing down. Is that right, Joel?
I think so. I think if you wanted to start in, maybe give it 10 seconds.
Okay, sounds good. Well, good afternoon, everyone. Welcome. This is a special meeting of the Indigent Defense Coordinators Group. My name is Wesley Shackelford. I'm Deputy Director of the Texas Indigent Defense Commission. And with me today, we have Joel Lawrence, Senior Policy Analyst from the policy team, Bill Cox, also with the policy team, and Crystal Leff-Pignon with our Family Protection Representation Division. Well, welcome everybody. Today we're going to tackle two things. We've got a lot to cover, but we're going to start with the indigent defense plans and an overview of how that works and a short demonstration. And Joel and Bill are going to take the lead on that. And then we're going to move to Crystal, who's going to preview the brand new Family Protection Representation Appointment of Counsel Plan process. With that, we have this in a webinar format, and so if you have questions as we go along, please put those in the Q&A, and we'll read those questions, and if they fit in the flow of our presentation, we'll try and answer them as they're asked. Otherwise, we'll reserve a few minutes at the end of the hour to answer questions as well. But please keep them in the questions in the Q&A. You can put other things in the chat if you wish, but we would like to keep the questions there. And I think with that, I'm going to turn it over to Joel to start us off on the indigent defense plans.
All right, thank you, everyone. Can everyone see the PowerPoint?
Not yet, Joel.
Oops. 1 second then. Didn't finish hitting share. All right, let's do it from now. Now you can see it, correct?
Yes.
Got it, Joel.
All right. Well, thank you, everyone. Today, we're going to talk about our indigent defense plan submission process. Some of what you hear today will be a little bit divergent, and that's because we also have new CPS plans, and they are on different systems. Our indigent defense plan submission, though, is on the same old system. Everything works the same as before. And so with that, let's talk about a few things. If you haven't noticed in the chat, there is a document PDF that is a guide for this. We're not going to follow that PowerPoint presentation the whole way. It's more or less as a reference guide. But we will have a demo in just 1 second. So indigent defense plans, they're required by section 79.036 of the Texas Government Code. Every 2 years, counties have to submit their indigent defense and juvenile delinquency plans to us. This includes a copy of all formal and informal rules, as well as forms that you use. It includes contracts for contract attorneys. If you host a public defender office, you have to have the plan of operation that was submitted to the commissioner's court. And if you host a managed assigned counsel program, you have to do the same. Every county in Texas has criminal and juvenile plans online with us, but if there are any revisions, you have to submit those revisions as well. Even if there are no revisions, you have to verify that these rules, forms, plans, proposals, contracts are the same. And so with that, let's go forward a little bit. Who submits and approves plans? Every county, as I said, has a criminal plan, but some of you have both a felony and a misdemeanor plan. The local administrative district judge is in charge of the felony plan. And if there's a combined felony and misdemeanor plan, the local administrative district judge must approve that plan. If you have a misdemeanor plan, the local administrative statutory county judge has to approve the plan. But if you do not have a county court at law, the county judge is the person charged with approving the plan. And if you have a juvenile plan, the juvenile board chair is charged with approving the plan.
For some counties,
go ahead, Bill.
For some counties, you will have a multi-county plan. This is especially frequent where you have district courts that have jurisdiction across several counties. However, some of you will also have a district plan that covers several counties, and then a separate juvenile plan and/or a separate county court plan. So again, look back at the website and you'll be able to see how it was structured as you're going through to be sure what is currently reported reflects your current practice and your current documentation.
Thank you. And any county employee can edit the plan. Often other people than these local administrative judges edit the plan, but the judge is the one who must approve the plan. So one of the most difficult parts of our system is logging on and approving the plan. It's not that difficult, but most of you probably don't remember your user ID and password. This is on our website. I've just copied the directions we have. You will have to go to the link that is highlighted right here. Oops, sorry. And if you forgot your password, there's a link to reset it. If you forgot your user ID, there's a link. If you've never logged onto our site, there's also a link to email Texas A&M. Texas A&M runs this site for us. Do you have any more comments here, Bill?
Not on this part. However, we have a question in the chat. And Judge Curtis, thank you for asking. If you are part of the Regional Public Defender's Office for capital cases, that does need to be reflected in your plan, and also reflect when you're doing your reporting later in the year.
So with that, I want to show you how you have to log into our system. Basically, you'll go to our website. There's a link that says visit TIDC's data portal. This is where you go to our login site. There's a link to log in. Hit that link. And this is the sheet. This is the page I just showed. I just copied the text onto that PowerPoint slide from here, but these are important links. So once you're here, and if you have your login information, you can hit login. Then you'll want to select your county if it's not already selected. I'm going to use Anderson County as an example. And to amend your plan, you'll say verify, amend, and then whichever plan you want. I will go through the county and district plan. One second here, as long as I can log in. Sometimes you maybe have a few delays like this, but here we go. So this is a little bit older technology. This is one reason we're going to a new site. The next time we give this presentation in 2 years, hopefully everybody is on the new site. But here we go. As you log in, you'll start off with a preamble section. We have a bunch of tabs at the top. They all contain different sections of the plan. The preamble is not required, but you're welcome to have text here. Anderson County included it. And if you want to make any changes, you'll have to hit save. There's a little save icon here before you move on. The first section of the plan that's required is the prompt magistration section. And in this section, on this pane up here, we have the required statutory provisions that have to be met. You can use your own language and handle it however you want. However, we do have templates that are like model rules that will meet all of these requirements. It may be useful to look at those, and you may need to edit the templates to match what you have locally. You do not have to use the templates, but they do meet all of our requirements. And when you do edit the plans, you can copy and paste from Word. Bill, do you want to say a few words about this? It can be dangerous.
Yes, Joel, thank you. As Joel mentioned, our current website is older technology. And so while you can paste in from Word, if you have any bullets or punctuation marks other than a period or a comma, it may cause some strange characters to appear when you paste in, and you won't see them until you save and then go back and edit your plan. So if you want to, which really is advisable, prepare your plan. If you're making significant changes in Word or another word processor, we would suggest only using periods or commas in what you're doing and what you're going to paste in, and then add any other punctuation marks, including even like quotation marks, once you've pasted it in over on the submission website.
Thank you. One other thing before I leave this page, if you want to see a reference to all of the statutory requirements for the plan, there is a link here. It says adult plan requirements with statutory references. This is a useful document. It's on every one of those tabs, but it'll include the statutory requirements for all of our plan provisions. So with that, let's go on to indigence determination standards. These are the plan requirements. You have to have a financial standard for presuming indigence, and you have to list basically the factors you used in determining indigence. A couple things I'd like to point out is there are different tests for determining indigence, and this is set locally. The most common test is a percentage of the federal poverty guidelines. Anderson County uses 100% of the federal poverty guidelines. That's a fairly common measure. They're usually between 100% and 200% of the federal poverty guidelines. Now, the federal poverty guidelines are amended each year, but they don't always keep pace with inflation. So you may want to consider what those guidelines are and say, is that a sufficient measure for indigence? Most plans have more than one test for indigence. Sometimes there is an asset test, which is used here for Anderson County. Most affidavits of indigence track asset information, but in practice, especially if you have a large volume of defendants, it's difficult to use. Many defendants are unaware of the value of their assets, or they may put in goofy numbers as to what those assets are. Maybe they'll have multi-million-dollar houses when in fact they're homeless. One standard that I really do like is public benefits. And that's because the federal government does the means testing for tracking this. You can use whichever public benefits you want to have, but the ones here listed are the most commonly used. So most counties don't have the resources to test things like the federal government. I really like it. The other thing I'd like to point out here is that if a defendant doesn't meet any of the standards listed, they can still be found indigent if they're unable to retain private counsel without substantial hardship. I think this is an important test. You may have someone who makes maybe $30,000 or $35,000 a year, and you say, well, they're not indigent. But if they're charged with a first-degree felony, the odds of them being able to retain counsel are probably pretty small. So it's very important to have this provision in your plan. Do you have any more comments about this section, Bill?
Just a couple of other things counties may want to consider. Some counties, in order to both avoid people slipping through the cracks while they're in detention and to expedite their screening process, have a presumptive standard once someone has been detained for a certain period of time, like maybe 7 days for misdemeanors or 10 days for felonies if they have not hired an attorney within that time. The other one is the section that Joel was just getting to, that we also want to try and give everyone participating a heads up on areas where we've seen issues come up when we do policy monitoring. And one of those is factors which cannot be considered. The only assets and income which can be considered are the defendant themselves and their spouse, or in the case of juveniles, their parents who have the duty to support them. But if they're like living with their grandmother, anybody else in the household, if they do not have a legal duty to support that person, then their assets cannot be included in the indigence calculation.
Thank you, Bill. Our next requirement that we look at is minimum attorney qualifications. This is often the largest part or the longest part of the plan. Here, the counties list they have their appointment lists that they use, and they list the objective qualifications for each list. If your list has changed, like maybe you've added a mental health section or you've combined previous lists, you'll need to amend this section. On top of including the lists and the objective qualifications, you have to list how many CLE hours in criminal or juvenile law must be obtained by the attorney each year. And there has to be a provision that attorneys have to submit their practice time report each year. Do you have anything else, Bill?
I think that covers it.
Okay. Prompt appointment of counsel. This is not necessarily a long section, but it's an important section. For counties over 250,000 people, there's 1 working day to either appoint counsel or deny indigence. And for smaller counties, it's 3 working days. We have a requirement that if somebody makes bail, they still have to be found indigent or not indigent within that time period. There has to be, if someone comes to court without counsel, there has to be a procedure to explain how to request and obtain counsel for those defendants. And if someone wants to request counsel prior to the initial appearance, there has to be a method for those defendants to request counsel and be able to submit the requests. As an example, I want to include some templates here. They're very useful, and a lot of counties have used them. The important thing with these templates is that there are blanks. And if you use this template, you actually have to fill in the blanks to say who is the appointing authority, for instance, in misdemeanors or felonies. Many counties allow defendants to obtain the forms for requesting counsel, that is the affidavit of indigence, from our website. Some use a different method, and if you use this template, you'll have to specify on this blank where you can obtain those forms and where to submit those forms.
When we're talking about the prompt appointment of counsel, remember as you're drafting and updating that those timeframes Joel highlighted of 1 day for large counties and 3 days for smaller counties start running at the time the request is made. So for instance, if it's at magistration, like most of the requests happen, once that request happens at magistration, the time frame will begin running there rather than once the actual indigence affidavit is received. And then again, as he highlighted, with a lot of the plans refer to our website to get indigence applications. For people who want to request at a different time, if you're going to do it on a local website, then you'd want to be sure and list your local website as well.
Very good. Onto attorney selection process. Some of you will have to amend this section. We've had a lot of new counties join regional public defender offices, and in this section, you'll have to describe that. And some of you are members of the capital murder public defender office, that will have to be described as well. We have a template here. If you are a member of the capital murder public defender office, but you have a rotational system, we have a template that you can use right here. And it has language for capital cases where it says the regional public defender for capital cases shall be appointed to all capital cases unless good cause exists to appoint private counsel. If you have joined a regional public defender other than that, we also have a template for that. And it basically will appoint counsel, I think, to all non-conflict cases. You'll have to determine locally, as to the wording for the plan. Let's suppose the public defender office were to take 50% of the cases, you would want to mention that in the plan. Any more comments on this section, Bill?
I think we've got it.
Okay. Fee and expense payment process. You may have to amend this. Ideally, this should be aligned with your fee schedule and fee voucher. You can include dollar amounts in here, but it can be a little tricky because if you adjust your fee schedule, ideally, this should be adjusted as well. One thing that we sometimes see is that we have a requirement that attorneys have to be able to submit reimbursement requests without prior approval from the courts. Sometimes we have new judges and they don't like that and they take that provision out. You can strongly encourage attorneys to seek prior approval, but there has to be a provision that if they cannot obtain prior approval, that they can seek reimbursement, and those expenses are supposed to be reimbursed if they're reasonably necessary and reasonably incurred. So with that, I think we can go to the forms.
Let me highlight one item that Wesley answered in the chat. However, again, just so to be clear, small counties are those under 250,000, in which where you have 3 days to appoint counsel from the request. For the counties over 250,000, then the request has to be ruled on within 1 day and counsel appointed within the next working day.
Thank you. So the final part of the plan is the forms. Almost everybody probably needs to adjust this section because, as you know, we've had a little bit of inflation over the last few years, and a lot of you have had new fee schedules. If you have other forms, perhaps the affidavit of indigence is changed or a new magistrate warning form, you should upload those forms as well. Many plans have old forms that need to be archived. And to do that, you can contact our folks at Texas A&M here. What sometimes happens is we'll have old documents, and they may be an old Word doc, a DOC document. You'll have to talk to our folks at Texas A&M to have those removed. If you upload a new form, let's say the fee schedule, you'll click this button, and then you can browse the computer and then pick your file and upload it. If it's like a PDF, and you already have a PDF fee schedule, it'll automatically replace the old fee schedule upon approval. Here they have a DocX fee schedule, and that's fine. If your new form is a DocX, it will replace it. However, if they're different types of files, they will not replace the old forms. So if you want to put in a PDF here, then you would have to call Texas A&M and say, please remove the old fee schedule. So, Bill, did you have any more comments on this section?
The only one on this section that really applies to a lot of the updates is especially if you have any new judges on the bench. You may want to just print a copy of the entire existing plan to be sure they're aware of it and see if there's any updates. A, just with change in practice. B, to be sure they're aware that it does have to be reflected in the plan. And then C, so that if there's any new forms or any other information, that can be uploaded and so that it's going to be available for everyone to look at. The other item that we didn't take a deep dive into, but just to put on everyone's radar, is you have to have a procedure for appointing counsel for anyone arrested out of county when you receive the requests from those other counties, or to send the requests to the county where the warrant was out of for the person who does get detained if they're in your county.
Thank you. Now, Bill mentioned you should probably review your plan. If you go to this plan submission tab, there is a link that says view under review plan, and that will show you a nice printable format for this. You don't see all the different tabs. This is a document you can copy and paste it into Word, and you can see the entire plan in a readable manner. I'd probably suggest also, that you do this. Anyone from your county can edit and submit the plans. After someone is finished saving and editing the plan, they would hit the submit button. That will generate an email that will go to the administrative judge over the plan. And that judge should receive an email that says, please review your plan. If you want to approve it, hit the approve button. But if you have issues with it, then don't hit the approve button. The one problem we have is there are a lot of email servers that block our notifications. And so if your county employee makes a change and you do not receive an email, you'll have to log into our system. You were about to say something, Bill?
One other item from our other question in the plan deals with Operation Lone Star and updating plans to reflect what's happening with those appointments. There is currently an emergency Supreme Court order for indigent defense covering counties that are served by an OCA central magistration office that is then covered by policies which TIDC have adopted under that Supreme Court emergency order. However, the best practice would be to go ahead and add language that also mirrors that into your plan in case we were to reach some point where we don't have the Supreme Court order and we're still working with Operation Lone Star. And for that, on our website, on the Operation Lone Star page, there is language that we would suggest placing in the plan if you're a county that's working with centralized magistration and Operation Lone Star.
Very good. Well, those are the main highlights here. One thing I just want to highlight again is anyone can submit the plan. Only the administrative judges can approve the plan. And if you're an administrative judge and you do not receive an email, you will have to log in, go to this tab that says plan submission, and then hit this button. If somebody has made changes and you are the judge, this should be highlighted and you can hit the button and then you're done. It's not complicated, but you'll have to be able to log into our system and find the link and hit the approve button. And hopefully in 2 years, we will have a much more easy to access and easy to administer plan site. So with that, I think we are done unless there's questions, and we will turn this over to Crystal, and we'll have some question time at the end.
All right, any questions y'all want to answer now before I get started?
We don't have any more in the Q&A.
Okay.
Thanks, Crystal.
Well, hi, everybody. I'm Crystal Lefpignon. I'm a senior policy analyst here at TIDC. I exclusively work on our Family Protection Representation Program, which is commonly referred to as CPS. Some of you here on this call may not do any CPS work. Some of you may be responsible for everything in your county, or you have friends who do have to deal with the CPS work. So, listen in, and if you have questions, please reach out. We're happy to help. So I'm gonna start sharing my screen and give you a little bit of information about the child protection plans that we are rolling out this year. All right, does that look good, team? Yeah, okay, cool. All right.
Yes, we can see it, Crystal.
Okay, thanks, Wesley. Okay, so the law regarding reporting for family protection services is found in Texas Government Code 79.0365. Now, for those of you that have worked on this reporting in the past, the first time we did this data collection was 2 years ago, November of 2021. And that data collection was actually found in a different part of the government code. Senate Bill 2120 that was passed this last session did a lot of cool things. One of the things it did was it gave TIDC more responsibility to start working to improve the court appointment system in child protection cases. And it also moved the data collection section. So the new home for data collection for family protection services is now in 79.0365. So for those of you that have done this in the past, you may be thinking, I thought it was in a different part of the code. It was. You're not imagining things. It's just now has a new home. So if you want to look up the full section, you can find that there. Similar to the criminal and juvenile plans, they are due every other year on November 1st of odd numbered years. So we will have another round of reporting due this November. For all family protection plans, the local administrative district judge is responsible for the approval of the plans. The statute specifically lists different things that are required for counties to provide in the reporting, and I have them listed here. It is similar to reporting for criminal and juvenile. It's in the manner prescribed by TIDC. And we have put together a website to help get this data in for to meet the requirements of this statute. So this is one of the big things this year, and a big thing to know. So our data collection website at TIDC is going through a phased update. We are working to, as Joel mentioned, it's a little bit long in the tooth, that website, and so we are working on updating the entire site. The Family Protection Plan is part of the first phase. So this reporting cycle, the Family Protection Plan will be one of the first parts of the site to go into the new website. So the thing to know there is the website is different. So you can see the site here on this slide. It's a different website than the original site that Joel and Bill were just showing you. It's a completely different website, so keep that in mind. If you go to the website that Joel and Bill were just showing you, you will not be able to access the Family Protection Plan. So if you're on that site and thinking, where is it? It's not on there. You'll need to go to the new site. So the logging in it's a little not tricky, but not as seamless as we would like. I would just mention this is the very first phase of our data website update. And as with anything that you do that's new, there will be glitches or errors to be expected. So if you are entering these plans and you experience a problem, I would just ask that you be patient with us. We are doing our best working with PPRI to make sure that this provides the best experience for you all, but we certainly can't promise that it's going to be perfect this go around. So to get into the site, remember it's that different website, but you can use your same login information for the original TIDC website. So you can use your same username, you can use your same password. So that'll be the same for both sites. Now, if you know your username, but forgot your password, on the homepage for that site, there is a little link that says forgot your password, and you can click on that and get your password. If you don't know your username, or you need to obtain a username and password, you will need to go to the original data collection website. This is the thing that's a little bit wonky with how this works. This will get better with time, but for now in this phase, this is how it will have to work. So keep that in mind. If you don't know your username, or you need a username and password, you will have to go to the original website, which I have listed here. All right, so I'm gonna switch over now and walk you through the actual website. Make sure that it works properly. All right. Okay, does that look right, TIDC team?
Yes.
Okay, perfect. Okay, so this is what the new website looks like. Very exciting, right? So when you go to that website, this is what you're going to see. The first thing you're going to want to do is see up here at this top, you're going to want to go to login. Click login. And this is where if you have the same username and password from the original site, you can type that in here. I auto-populate because I forget things, but you can type yours in if you know it. This is where if you don't remember your password, you can click on that forgot password. If you don't know username or password, if you're like, I have no idea what my username is, you have to go to the original website. And then you go to log in. And then it will take you here. This is what you will see. So for y'all, when you're looking at your site, the only difference between my view and your view is up at the top where it says management, it will say county for you. Mine says management because we have the back end view, but yours will say county. So when you first come here, you're going to want to click on county. This attorney reporting, just for y'all's knowledge, that's where people can go to do their attorney practice time reporting, which is also new and is also part of our first phase, but y'all don't have to worry about that for the Family Protection Plan. So click here, it'll say county again. And then this takes you to the next part of the site. You want to click on your county. So here you can see a drop down of all your counties. Click your county. I'm going to pick on Anderson just because they're first in the alphabet. And then you will hit update plan right here. Then it asks you a question. So this is a helpful question for those counties that cover multiple counties on their circuit for CPS cases. Some judges have the same plan for every county that they cover. So instead of making you fill it in every single time, you can copy a county's plan. So if you've already filled one county in, you can copy it for the other counties that you cover. And you can choose here. If you want to choose a county that you cover to copy, you'll pick your county. If not, maybe you only cover one county, or maybe your plans are different, then you would click do not import county data. An important thing to note here, this will not copy anything from the old reporting site. So if you did a CPS plan last time in the old or the original site, you can't copy that in. You can only copy a plan once it's been entered into this new site. All right, so I'm not going to copy a plan. I'm just going to go on in. And then here we go. This is what it now looks like, the new fancy site. So for the family protection site, we have 9 different sections for this plan. You do need to go section by section when you first enter the plan. So our first section here is appointment list. What we've tried to do is to make this as user-friendly as possible, cut down on the need to type things in. So you'll see a lot of radio buttons, drop-down lists. So right here, it's a simple, do you have more than one list? How many attorneys? You can type that in. How many attorneys accept appeals? This is really information gathering. We're trying to get a good understanding of what's happening in our state so we understand what the needs are and we can try to improve where we need to. So once you've entered your information, I'm just going to put 1 and 1. If you are Anderson County, if you happen to be on the call, don't panic. I will clear this out as soon as we're done. These won't be your answers. Hit save and continue, and then it takes you to the next section. It will guide you through the site. You have to hit save and continue though to move to the next one. The way this site functions is you cannot click from section to section until you've completed the section. Once all the sections are done, you will be able to jump around, but not until you've gone through all the sections. So next one is joining the appointment list. See, again, you'll see there's check boxes. Again, we're trying to make it as simple as possible. So I'm just going to do, again, these are not the real answers. And you see all of these different questions here. You can fill in boxes if you need to, just kind of follow along. If you have specialized courses, you can add your CLE course and enter the name. And then you get to the bottom and hit save and continue again to get you to the next section. This one is maintaining the appointment list. So what are the rules to stay on the list, essentially? That previous section was how do you get on it? This is kind of staying on it. And again, with the same question. So I'm not gonna answer every question, but we've got simple questions again, check boxes. Our goal is that this is pretty easy for the people who are filling it out. And then I will go to save and continue again. Next section is caseloads. Simple yes, no questions. Boxes to enter if you do have caseload standards. Most counties don't in CPS cases, but in case you do, it's there. Then we have questions about, appointing cases to lawyers. What are your methods? What are your reasons for off rotation? You'll see again, these are just very simple buttons, check boxes, and save and continue, and it takes you to, oops, oh, I didn't like that. Okay, maybe because I didn't answer a question. Let's see. I will say, if you are working through this and you experience an error, please reach out. You can reach out to me and we will get with the website. See, this is enough. It worked for me yesterday. Let me see if I can get through. If not, then I will just talk you through it. If not, we probably just have an error on this. Let me let them know. Okay, well, unfortunately now it's not going to let me through, which is an issue. So if you experience that while you're working through it, just reach out to me and we will get with PPRI to discuss what to do. So I can't tell you the rest of it, which really stinks. But what I will tell you is you will follow the same methodology through each section, 6, 7, 8. The 9th section here, the final one, plan documents and submission, that is where you will enter your forms. So things like affidavit of indigence, fee schedule. The statute requires, it specifically mentions the requirement that you have to upload your fee schedule. It also requires any other, it's very broad, any other relevant document relevant to your court appointment system for CPS cases. We do have specific lines for the obvious ones, like I said, affidavit of indigence, your fee voucher, your fee schedule. There is a section for other, so if you happen to have a document that doesn't fit in one of the categories that is on there, you can upload that as well. When you upload your document on that section, there will, if you've uploaded successfully, you will see a green checkbox. So that lets you know it's been uploaded and it's been successful. If you happen to have a lot of documents, I know that some counties do. If you need more other boxes when you get to plan documents, you can reach out to us and we can add some lines for you. And I'm going to stop sharing that site since it's not working. I'm going to go back to my PowerPoint. All right. So we talked about plan documents and submission. So that 9th section is where, again, you upload your documents, and then it's also where the submission is going to take place. So although the law requires that the LADJ is the judge who officially approves the plan, the local administrative district judge does not have to fill it out. So if there's another judge in your county that mostly handles CPS cases, that judge can fill it out, or even court staff or someone else who maybe is able to answer those questions. That person can fill it out. The rule though requires that the local administrative district judge approves the plan. So if a person other than the local administrative district judge fills it out, you'll want to hit submit plan. You'll see it at the bottom of section 9. You want to hit submit plan. And then from there, the local administrative district judge should be notified that the plan has been submitted for approval. Now, like Joel mentioned, sometimes there's email blockers and you don't get the email, especially with this new site. As you've seen, we've just had an error when I did not expect it. I would suggest you also notify your local administrative district judge. So if you are a person who's not, who doesn't have approval authority, it's probably a good practice just to reach out to that judge and let them know it's done, it's ready for approval, so the judge can go in and review it and approve it. And let's see, we talked about documents already. Okay, so there's my contact information. You may experience errors. That's okay, like I did today. You can reach out to me, email, phone. We also have a general data info website that you can send questions to, and I can answer them. One thing I will let you know is the website is still actively being worked on, which may be why we experienced an error right now. It is not ready for the public to use. So if you're an early bird, which we love people who are nice and on time, that's great, but not on this plan. We will let y'all know when the plan is ready for the public to use. We will be notifying all the local administrative district judges in the state. They will get a letter and an email with very detailed instructions how to use the new site. Once the local administrative district judges get that information, the site is ready to go, and anyone can use it that needs to use it to enter the information, but not today. So with that, I think that is all I have. I will stop sharing. I don't know if there's any questions, Wesley.
There aren't any questions right now, but this is the time to ask them. We've answered a few as we've gone along. I don't know, feel free to put some more in the Q&A if you have any. You can also raise your hand as a participant, and we could, I think we can let you ask the question orally as well at this point.
We had a question from our interim director, and he was asking about the timeline for getting requests for counsel to the courts. And it's 24 hours. That has to be in the prompt magistration section of the plan. And when we look at the total timelines, it's that plus the either 1 or 3 working days.
we did just get a question. Are there any templates for the CPS plans? And yeah, it's a little different setup, isn't it, Crystal?
Yes, it's very different. It's very different from the original TIDC website. We're trying to minimize the text boxes. So there are no templates because it's very much you'll click buttons or there'll be drop-down boxes. There are a few boxes that you'll need to type things in, but there's not very many. So we don't have, we have no templates because the idea is hopefully you won't have to pick them, which is our goal. I think there was one more question about the CPS plan. Yes, and I don't love this, and I am sorry. I really am sorry. As you can see, our developers are working on this site literally, I think, right now as we do this. We did want to let y'all know that this is coming, and so it wasn't a huge surprise and a shock. But as of right now, I would not recommend you go in there and try to use it because you may experience an error, just like I did right now. And so it's technically you could go into the site right now, I think, and try to log in, but it's not. There are some features that are still not complete, and we want to avoid errors. That's so frustrating for you if you sit down and you're trying to do this. So yes, I would recommend do not try to enter information until your local administrative district judge is notified, which we do plan you know, a little later this month to get that information out once we get the official 100%. The website is completely done, and hopefully y'all won't experience any errors.
Yeah, there'll be a letter going out to the local administrative district judges that will include plan submission instructions for both the CPS plan as well as the criminal indigent defense plans. And there will be courtesy letters to other local officials as well, just with the information about the submission process. So as Crystal said, we'll send those as soon as the website is ready. I don't know if we can say a time, but hopefully next week. And there's not a super critical deadline. I mean, the statute does say November 1st, but it's not as if November 2nd, there's going to be some sanction imposed on a county. So you know, take a breath, we're in good shape.
Right. And this is only, oh, sorry, Bill, I was just going to add, this is only the second time we've done the judicial plan data collection for child protection cases. So it's still fairly new. So we certainly don't expect people to have this all ready to go on November 1. There is a little bit of a grace period. We are willing to work with people. So it's, you know, it's okay if you can't get it done by November 1.
We just received another question about, is there a requirement on how many appointment lists we have to have? And at a very high level, it's probably 3. 1 for the juvenile plan, 1 for the district and county plan. And then because death penalty qualified attorneys have to be approved by the list with the administrative judge for your judicial region, that would be a 3rd one. However, typically that's on the PJ list. But other than that,
Yeah. Oh, go ahead.
local standards for the criminal and juvenile side. However, Crystal, on the CPS side?
Yeah, there's not a standard either. We do ask those questions on the plan. That may be what you were referring to. You can just have 1, you know, that's most counties only have 1, but we ask those questions because some counties do have specialized lists. And so we want to learn more about that. But if you only have 1 list of CPS attorneys, you may have 1 CPS attorney in your county. That's okay. There's no requirement that you have more.
And Crystal, it looks like we got another question. Is the TIDC going to provide funding for CPS appointments?
Well, we're working on it. So one of the cool things about Senate Bill 2120, if you go and read it, you can pull it up online. It gives TIDC official authority to work on child protection cases. When we collected data 2 years ago, we were collecting that data on behalf of the Texas Judicial Council. We were just sort of providing a service for them. We didn't have any real responsibility or authority. Now we do. So the great thing is TIDC, during legislative sessions in the past, when they've gone to ask for appropriations to support criminal and juvenile indigent defense, now we get to do that for child protection work as well. So the data is very important. I'm really glad you asked that question. The data that we're collecting is it's the backbone of our request. You know, it helps inform us. What do our people need in our state? Where are the greatest needs? Where are the gaps? Super important. So one thing I would say, although we are obviously going to give grace to people because it is only the second time we've collected this data, the sooner you can get it in and get that data in correctly and well, the better we're going to be, because we've got to review it, we've got to make sense of it. And then our plan is next session to ask for money to support child protection work. So put some good thoughts out there, because we know that it definitely needs some support.
Thanks, Crystal.
We had another question. Joel's answered it in the chat. However, yes, if you came in partway through the webinar, we have been recording it, and our intent is to make it available on our website to be a reference as you're going through submitting your plans for this biennium.
And the PDF of the PowerPoint, that we didn't go through the entire PowerPoint, but there is a PDF of the PowerPoint which also overviews the whole process for both the CPS as well as the criminal and juvenile plans. Let's see, at the moment, I think that's all the questions we've received. We've got a few more minutes. By all means, if you've still got a question, type it in the Q&A or raise your hand, and we'll give it a minute or so. And if not, we might turn it back over, as you can have the rest of this hour to yourselves. Anything anyone else wants to add from our presenters, just while we have a second?
We understand the process can be a little challenging, whether it's with the new CPS website or updating your plans. Please feel free to reach out to any of us on the call or to the support emails we have online for A&M, who does our programming at the Public Policy Research Institute, and we'll be happy to help you. And the other question we just got is dealing with information on the old site transferring to the new site. I'm guessing that's dealing with the CPS data.
So because we've substantially changed the way the CPS form is done, the data is not going to transfer over. For those of you that did the plan 2 years ago, it was kind of like a one long website, and you would go in, and it wasn't, I didn't think it was that bad, really, truly. It was good for like a first go around, but it was just all in one spot. And there were a lot more text boxes because we had no idea what people were going to say. This was the first time we had done this. So it was very much almost like investigatory. Now that we do know what people have said, we noticed a lot of trends. So we created less text boxes, more radio buttons, drop-down menus, that sort of thing. So the data doesn't easily translate over because the questions are not exactly the same. Going forward, though, now that we're in the new site for family protection, the data will translate over and over year to year, and hopefully it'll get much easier as we go forward.
We also got another question: are we adding CPS to TechShare? And for those who don't know what TechShare is, it's a appointment management software system that was developed with state funding from TIDC and is now managed by TechShare, which is a part of the Conference of Urban Counties. And there's at least a couple of dozen counties, maybe more, that use it. It helps automate the process of maintaining your appointment wheels, ruling on indigence determinations, making appointments, and then on the back end, reviewing fee vouchers and feeding into the auditor systems for reporting the amount spent. So that's basically what TechShare is. It currently has functionality to cover criminal and juvenile appointments. I don't think we know the answer on whether it's going to be expanded to CPS or not. That is a possibility, but it hasn't really been discussed that I've heard. It isn't managed by TIDC, just to be clear. TechShare is a Conference of Urban Counties product, and they are the managers. So certainly those participating counties are owners of that product, and could could ask that it be, be developed further to allow functionality for CPS appointments. I mean, intuitively it makes sense, but it hasn't been done yet.
I believe there was one other question. I don't think we've answered. It was, is TIDC going to provide funding for CPS?
Crystal did tackle that. Yeah.
We hope so.
We hope so. Not this
Yeah,
year, not
that's
this
the goal.
biennium. Yeah.
Yes.
But we at least anticipate, visiting with our board about requesting funding for these cases to support counties this coming summer, and then to be taken up by the legislature in their next session, 2025. So it's a couple of years off before it might happen.
Yes, that is the goal. I will say, if any of y'all on the call are going to start thinking about revamping your tech systems locally, whether it be TechShare or some other, case management type software you're using, we're happy to, if you want to reach out to me and like, I don't understand what any of this means, I'm happy to talk you through things and what might be helpful, that sort of thing. We're happy to provide any support or assistance that you need as we enter the new age of also working on family protection work.
Bill, we received another question about what does the 3 working days to rule on a request for counsel mean? Does that include weekends or just the court's working days?
It's just working days. If it's a holiday, it doesn't include it. So basically, if you request counsel on a Thursday, there's 24 hours to get that request to the court. And then the court has 3 working days for small counties to rule on that. And working days does not include weekends or holidays. It's regular business days.
And just to clarify with that 24 hours is actually clock hours to transfer it over to the court. However, the court's time is working days.
Thanks. Well, at almost the top of the hour, any last questions? Give everyone just a few more seconds if they still have one. We really appreciate the attendance. By my count, we had up to 66 folks attending, and so we hopefully this has been helpful. Once again, we will be posting a recording of this. You can see the PDF of the PowerPoint presentation, which really details what the presentations covered today. And look out in your mailboxes. All of our administrative judges, our constitutional county court judges, also our county auditors and indigent defense coordinators will also get courtesy letters when the plan submission process is ready to launch. And then any of those judges who are what we call approving judges, the local administrative district or county judges, juvenile board chairs, will also get emails shortly after those instructions land in your inbox in hard copy with links directly to your plans so that you can go log on, review, and submit your plans at that time. So that'll probably follow it just a few days after the hard copy mailouts arrive. And let's see, it looks like we just got one more question from Jessica in Navarro County. I have received affidavits that are not completely filled out, but the applicant received government assistance. Can I decline for incompleteness?
Well, I would say what you need to look at your indigent defense plan to see what it covers. You can deny for incompleteness if it's really incomplete, but sometimes people have disabilities and have a hard time filling out these forms. So if you just see lots of zeros and blanks and it looks like the person has ability to fill this out, I believe you can deny for incompleteness, but you don't want it to be onerous because there's a lot of people that just have limited reading and writing skills. And if they can show that they might meet your qualifications for indigence, you should appoint counsel based on that.
2 other items. One, again, as Joel said, look at your plan. If your plan automatically qualifies for government assistance, then the other blanks may not be important. The other piece is this may be an indication you may have someone who needs additional assistance or screening for mental health or intellectual disability and may qualify on those bases.
Good point, Bill, and thanks for the answer, Joel. With that, we're coming to the top of the hour, 1 o'clock. Thanks everybody for participating, and unless anyone has anything else to add, I think we can call it a webinar. All right. Thanks everyone. Take care. Have a good afternoon.